Hey everyone, this is Rob Ryder. It's August 5th, 2012. And before I get going, I have a problem with my Skype. I can hear what people say, but when I try to talk back, they hear it garbled, and it seems like it takes a long time for things to happen. I thought it was the microphone I'm using, but I'm using the same one now on this video as I do to Skype with. So I'm not sure what the problem is. If anybody has a clue, please let me know. I've reloaded Skype. Still doesn't work. Um, Maybe it's a computer. I don't know. So, for that reason, I started this talk show where a lot of things I'm going to be doing will be from now on as far as talks and so forth. But my email address is quarterrecord@aol.com. The talk show is called Taking Clues from Ancient Books. You can find it that way, or you can put in the call ID. You can search on either of those to find the call. And we've only done one, but it had some pretty interesting things on it. And really is leading to what we're going to talk about right now is where to find their confessed judgment. It's in your property file if you've lost your house to foreclosure. Now, I'm not going to say this is for everything, but I'm going to say if you look at this and you've lost a house and go look at yours, see if you find the same thing, and if you do, well, we're going to figure out where to take a complaint. So, special thanks to Lawton in Georgia who pointed this out on his call. He looked at the deed they gave him after, well, not the deed they gave him, the deed between the lender and the purchaser that's now on the record in the property record when they sold his property on the courthouse steps. And so the things I think you're going to need to make this happen, certified copy of whatever the foreclosure sale deed is, whatever they call that, whatever's in there now, giving the property to somebody else, a copy of the warranty deed that you were the grantee on, and a copy of the first lien security instrument called a deed of trust, mortgage security deed, whatever it is. When you get these, those will be your evidence under seal. And once we have those, we want to go find the one court of justice. So now let me show you how they self-confessed. So in Georgia, they use a thing called a deed under power of sale. Like it says, used after foreclosure sale. They can't make it any clearer. So this indenture made, whatever days, the debtor is the borrower, so that's you. Hereinafter you, acting through lender, them, duly appointed agent and attorney in fact. So what that's saying is you are working through the lender, and the lender is your duly appointed agent and attorney in fact. If you didn't know that, they just confessed to it. And you are the party of the first part. So that's you as the party of the first part is them, right? They're your agent and attorney in fact, representing you, the party of the first part. And then there's whoever the purchaser is going to be. He's going to be the party of the second part. I got to read that again. So are they acting as the agent and attorney for both? That's even more interesting. I got to think about that. I didn't see that till now, but it looks like they're saying that appointed attorney in fact hereafter referred to the lender as the party of the first part and purchaser as the party of the second part. Well, what do you think? Does that say that they're doing both? They're at least doing one. They're at least being you. All right? And I'm going to base all this on them just being you, so it's enough anyways. So, whereas you executed and delivered to them, the lender, deed to secure debt, so that's security deed, any kind of security instrument, deed of trust, mortgage, anything that conveys a security interest is a security instrument no matter what the title is. It's a security instrument. It's not the lien. It's the security for the lien. And it says where it's been recorded. Okay. To secure payment of a note, some note that was dated some date, hereinafter referred to as the note. I don't know. Do they actually put that on there? I guess they do. And whereas default under note occurred, so something under the note defaulted, not the note, default under the note. By reason of such default, them elected pursuant to the terms of security deed and note to declare the entire principal interest immediately due and payable. So they're doing this on your behalf is what they're saying, because they are, right now they are them, or they are you. They're representing you. Whereas said entire indebtedness still being in default, the lender, on behalf of you, according to terms of security deed, so as your attorney in fact and your agent, did advertise the said property for sale once a week in the newspaper for 4 weeks in the county of, okay, so that now they're going to advertise your property for you. Whereas them, again, this is the lender, as your attorney in fact, did expose the said property for sale at public outcry to the highest bidder for cash. All right, so they sold it for cash for you because they're representing you. They're your agent on whatever day it was within the legal hours of sale, if they did. So, did it happen on the first Tuesday? Is it within the legal hours? I don't know. We'd have to go find out what they are. In the county, before the courthouse door, wherever in Georgia, at which said party, the second part, the purchaser, was the highest bidder and for the sum of however many dollars in cash, which is yours, and said property was then and there knocked off and sold for said sum. And so they used this word knocked off, and this is what got Lawton's attention, so he went and looked at the definition of knocked off. And, it's an unauthorized copy, usually for the sale substantially lower price than the original. Well, jeepers. I wonder if that might have happened. To murder, well, they didn't quite do that, but they robbed or burglarized. And it's an unauthorized counterfeit, and usually inferior copy of another's product, especially one protected by patent, trademark, trade dress, or copyright, which is what your warranty deed should be, is your copyright, usually passed off at substantially lower price than the original. So you're going to see that they've sealed this with their seal under the oath of a notary. In my opinion, they just confessed to counterfeiting. And I think we should point that defect out to an officer of the law. Let's go on and see if they do some more. Now, therefore, for and in consideration of the foregoing premises and said sum of money, and by virtue of an exercise of the power of sale contained in the security deed, you, has bargained, sold, granted, conveyed, and by these presents do hereby bargain, sell, grant, and convey to the purchaser, okay, whatever was Exhibit A. And he didn't have it on here. I have to imagine Exhibit A is the warranty deed. Could be the title deed. I don't know what Exhibit A is, right? But whatever Exhibit A is, if you have one, you're going to make sure, if you had one of these in yours, that you looked for the Exhibit A. Where's Exhibit A? It says there is one. It better be attached. If it isn't, that's another thing to complain about. For in consideration of the foregoing premises and said sum of money. So what this is saying is, now therefore, for and in consideration of the foregoing premises, so whatever the premises is, and the money, and by virtue of and an exercise of the power of sale contained in the security deed, you, right, so you got the foregoing premise and a sum of money, and for that you've sold, granted, and conveyed the property to the purchaser. And the property is described in Exhibit A. So again, this attorney in fact slash agent, who the lender says they are, and they've done this on your behalf, is holding all this for you. Apparently. That's what they're confessing to. And then together with all and singular the rights, members, and appurtenance thereto, appertaining also all the estate, right, title, interest, claim, or demand of you, the borrowers, them, so you, the representative, heirs, successors, assigns, legal, equitable, otherwise, and of the same. So you're all giving away your rights, title, and interest to whatever Exhibit A was. And for that, you got consideration the foregoing premises, and a sum of money. And so what was the foregoing premises? What have we talked that we've done so far? Other than we talked about, this is the security instrument, which is, what's the definition of premise? When you look at it, you're going to find it covers everything. So a security instrument can be a premise. So for the foregoing security instrument and some cash, you're going to give them the warranty deed, and your agent has done this deal for you, but, has he given you the check yet? Because they're saying on here, they're doing it for you. Okay, to have and to hold the said premise and every part thereof unto said party of the second part, so to the purchaser, its representative heirs, successors, and assigns to its own proper use, benefit, and behoof, in fee simple, capitalized fee simple, capitalized to have and to hold. It's almost like it's fiction. In as full and ample a manner as you or your representative, them, heirs, successors, assigned, did hold and enjoy the same. Basically, whatever you had, you gave to them. Okay. Before that, you get the premise and cash. Where's it at? The notice of the foreclosure sale, as required by Georgia law, in the form of a copy of the notice of sale under power submitted to the publisher, was provided to the borrower. So did you get a copy of this? Right? At least 15 days prior to ask them for the proof that they gave you a copy, because they said they did. In witness whereof, them, as the agent and attorney in fact for you, have hereunto affixed its hand and seal, this day and year, first above written. Well, so that right now they're going to confess under seal that they've done all this for your behalf. And so they're holding whatever the foregoing premise was and all the payments. They're yours. So out of that, this is what I got. Here's a place that they confessed, right? First of all, they said that they're your duly appointed agent and attorney in fact. Well, they claim to be your agent. They have therefore breached their fiduciary duty to you by concealing the truth. Right? They didn't work in your best interest. It's more like they were working against you, yet they're supposed to be your agent and attorney in fact. I think that's breach of contract. So the borrower or you executed and delivered to them a certain deed to the secured debt, the security instrument. Well, yes, you executed and delivered to them a deed. They never executed the deed as grantee, and therefore they're in breach of contract. They themselves set it to deed. And for a deed to be lawfully executed, both the grantee and the grantor must acknowledge the deed. They have not done that yet. It's not on the record that they ever acknowledged the deed of trust. We're talking about the security instrument here. Deed of trust, mortgage, security deed, whatever they call it in your state. Well, further, them, on behalf of you, they're selling it for you. So the cash is yours. So is that foregoing premise. And whereas they, as attorney in fact for you, did expose the said property for sale at public outcry to the highest bidder for cash, it's yours. Right? So where's the cash, including its gains? And the said property was there and then knocked off and sold for said sum. Well, counterfeiting is a felony. So now it's fraud. So it's 3 times damages owed if you do it as a criminal case. It's already happened. They've already committed the crime. And Blackstone says that you get to a certain place in a civil matter, for it to go any further, fraud has to happen. And it's implied consent between at least 2 parties. So the court's going to let them commit fraud to take your stuff. If they want it that bad, they'll let them commit fraud to do it. That's the only way they're going to let them have it. If you ever find out later, you're going to get 3 times damages. Well, this has already happened. So you're not looking for money judgment. You want it to be a criminal matter, because if it's found to be criminal, you get 3 times damages back. So here's some things you need to ask, right? did they have a license to do business in the city? They're saying that they're representing you. Well, to do that, to do business in the city, they have to have a license or a franchise. If they don't, then it's false representation. Well, I don't know what else it'd be. But basically, they don't have a license. They broke the law. That in itself made it unlawful. Did they sue you in the name of a fictitious plaintiff? Right? So if this happened in a court case and, you went to court, whoever the plaintiff was, if it was a fictitious plaintiff, well, that's contempt of court, to sue in the name of a fictitious plaintiff. So what are you going to do? Well, you're going to take your complaint to the Attorney General for the municipality, city, township, borough, precinct, etc. Basically, to the city attorney. Some people have gone and asked these questions to this office before, have been told, well, what they try to do is they say, well, it sounds like it's a civil matter. You're going to want to go over here to put your complaint in. And if it's a civil matter because you're looking for a money judgment. And you say, no, I am here to put in a criminal complaint because I have the evidence that a crime's been committed. So you do not answer into their private courts, right? You don't take this back to the county court or the state court or whatever they call it. They couldn't make it any plainer that these are private companies. Just look them up in Manta. They say that they're private courts. Well, you don't need to go there. If you only go there if you consent to the jurisdiction, but you don't need to consent. You stay right in your domicile where you have protection. So, we're not going to put a court case together, nor are we submitting a civil case looking for money judgment. You do not want a money judgment. No, 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 no. You want justice. They committed fraud, and the remedy, the equity, is already built into fraud. It's 3 times damage. And what's the damage? Well, whatever they took from you. And they've already put up their bond. Because to start this case, believe it or not, they had to go to your domicile in the county and actually put under oath that they said it was their property, not yours. And you're going to catch them now in this lie, and it will be found to be fraud, and you will get 3 times damage. So what you're doing is you are bringing misprision of felony to the attention of an officer of the law. And for him not to take your complaint as a criminal matter is misprision of treason on his part. So tell him. That's why you're there. It's misprision of felony. And it's misprision of you to know of a crime and not to bring it to an officer of the law. Look up the definition of misprision in Bouvier's. I should have put it on here, but I put it on other stuff, and it's easy enough to find. Just go look at it. Look at the definition of misprision. If you're a good citizen, and good and God mean the same thing in Bouvier's, if you're a God citizen and you know a crime has happened and you don't report it, you're guilty of misprision. So you're just following the law. And then you're going to demand that this be taken to the one court of justice. No, I don't want it to go to the district court, or you don't want to go to any private court. Say, this isn't going to any private court. This is going to the one court of justice. And it starts at the township level, city, borough, precinct, whatever you call it. And the Supreme Court has concurrent original jurisdiction in all matters. As soon as it goes into the one court of justice by a justice of the peace, putting his seal on it and putting it into the docket book as a criminal complaint, the Supreme Court has just gotten concurrent original jurisdiction in the case. I'm going to tell you, they're going to make sure the law is followed. That's why they don't want you to find these justices of the peace and to know who to go to and to call it a money judgment and a civil judgment. And I'm telling you, just tell them, no, this is a criminal matter. And I'm bringing misprision of felony to your attention, to an officer of the law. And are you going to tell me you're not going to take it as a criminal complaint? Brother, that'd be misprision of treason. Now I really need to see a justice of the peace. So the reason why I put it in the one court of justice, which starts at your township, is this takes it out of their jurisdiction. It takes it out of the private courts. Those courts be it a circuit court, a Michigan State court, or a federal Article 1, Article 3 court, whatever you want to call them, those only exist in the organized state and the organized nation. They don't exist in the unincorporated federal district. All that exists there is Article 4 courts. And Article 4 is all common law, the law of nations. The plaintiff has to take an oath, man. That's why these people are going to stand up for you, as you're going to see, because it takes other jurisdiction. And you're going to find this in the video that I did on township powers. If you have an inhabitant in the township, it gives you're the elector in a township, and it gives you the power to appoint the supervisor, who's actually the deputy, as your agent, and the township attorney as your attorney, to sue and be sued on your behalf. Well, they just became your sureties. In common law, your sureties were living men of your town. So if you got in trouble somewhere, they'd come get you, say, well, make sure he comes back for the hearing. But you didn't stay in jail. They put themselves up as surety. If you didn't show up and it was a real crime, right, they had to answer for it. So they're going to make sure you don't get charged with anything but a real crime. They're the caretakers of the city. They make sure that the only thing that touches you, well, nothing can touch you. You've just appointed them to sue and be sued for you. So you're the king, man, and you just claimed your position as the king. So, I don't know what they call it in other states, right? But everybody has something like this. What happens after they foreclose on your property? Go get a copy of the dang thing and read it. I mean, I'd never read one before. Now that I had it, it's like, well, shit, I'm not going to disagree with what it says. The lender is a duly appointed agent and attorney in fact for you. Well, he breached his fiduciary duty because he let your shit go, right, and be counterfeited. In fact, he says he counterfeited it. So it's definitely a breach of fiduciary duty. Right? They did a knockoff. Where the heck is knockoff, right? An unauthorized counterfeit. Your attorney in fact, an agent, has admitted to counterfeiting. I'd say that's a breach of fiduciary duty. I'd suspect somebody may go to jail for this. And you'll get 3 times damages back. And really, it was based on one word. Knockoff. Knocked off. What is that word, knocked off, doing in a legal document? Well, it's called self-confession. They have self-confessed to counterfeiting and put it under seal with a witness in front of a notary, an attestation, and their seal. And then they put it in the property record. You couldn't ask for more evidence. That's why you get certified copies of whatever that deed is, your warranty deed, because I think that's attachment A they talk about on this thing. And the first lien security instrument, which is the one that was the recorded instrument they talked to at the beginning. You now have evidence under seal. All we need to do now is find out how to get it in one court of justice. And because the recorder, who sits as the chief circuit judge of a particular district in these small lowercase district courts, the courts of the territory, has conciliatory powers. He has the powers of the chancellor, and the chancellor can judge the law and give the remedy by himself. So really all this needs to do is get from your local justice of the peace, city court, one step higher if he doesn't have the power, but I think that they probably do at the city level because they control their city. They have their own court, or they have their own office, the recorder. But if not, the next level up is the district, and that's the chief district judge, circuit judge of the district that sits on that. And his office is definitely the office of the recorder, because that's the largest subdivision, political subdivision, that you could lawfully be part of in the territory. At one time, when Michigan was a territory, it was one county, the county of Wayne. It had one city, the city of Detroit. You could be in the big one, you could be in the small one, right? And then they kept splitting these counties smaller and smaller and smaller. But it's actually a district of land. It's just a territory of land. We got many, many districts, as you're going to see in some upcoming videos, about how they put these liens on us on the municipality level that we don't know about. And they've appointed an emergency financial advisor who's acting as a trustee. And it's where you first got into being the debtor under the under 11 Title 11, the Bankruptcy Act. But it looks like it's pretty easy to get out of, because it looks like it's a private contract. It's never been recorded. So it's one of the things I'm going to ask my court of justice when I understand it better. But if you have a property issue, right, take this stuff, put it on a piece of paper as a complaint, keep it short, keep it simple. Don't ask me to write it for you. If you write one up and it has more than 10 sentences in it, you wrote too much. Stop and go back. You get it down to 10 sentences or less, you want me to take a look at it? I probably do it. You got more than 10, or you're off on a wrong tangent, right? Then you're not paying attention to what I'm saying. And that's fine. Do it however you want to. I don't have this to do, so I'm not going to worry about it. But, all right. Enough on that. Good luck. See ya.